As you could hear, then when the war in Ukraine started, also we saw the international effort to call Russia to order in UN, also in New York, in Geneva, and in The Hague. There was already a session in March on the request of Ukraine when they wanted to discuss Russia's crime of genocide, but Russia did not show up. But somebody who was there is a member of our panel today, MYROSLAVA KRASNOBOROVA, who is the liaison prosecutor of Ukraine. And we will be able to ask her what the session in March was like. And in this panel in Tallinn, we'll have the Andres Parmas, who is the Prosecutor General of Estonia. So if you could also come to the stage, please. And this panel will have also two speakers over video, but we have few key words we should discuss. Of course, in the ideal world, we would know that Russia would be prosecuted. But in the news, we can hear that 2 weeks from now, on the 24th of February, when we are celebrating our Independence Day and war in Ukraine has its first anniversary, we will see that there are joint sessions of military exercises with Russia and China. We know that the United States is supporting Ukraine, but now there is an initiative of the European Union to establish a special tribunal to prosecute Russia for the crimes of war. Then United States is still considering this topic. We would like to see this discussed in the UN, but in the Security Council, Russia has a right of veto, and therefore there is no possibility for a decision to be made. That we have to wait for the General Assembly, but the General Assembly cannot make binding decisions. A special tribunal can be established, but then the question is who is going to bring the Russian criminals to the tribunal. So the situation in the world is quite complicated, and this is something we're going to discuss now. But before we continue from here in Tallinn, I would like to give the floor to New York, where we have James Goldstone, who is the head of Open Society Justice Initiative, and we'll hear his comments first from New York. The floor is yours.
Thank you very much. Can you hear me okay?
Yes, we can hear you. Okay. So your remarks, please.
Great. Thank you. In recent years, as democracy has receded in the world and authoritarianism has surged, human rights, the language, the institutions, the legal framework to which it has given birth over the past 3/4 of a century have come under a crescendo of criticism. So it is said that rights defenders take more satisfaction from being morally pure than practically effective, or that human rights have become a lawyer's playground, freighted with legalese and dominated by those with legal training, sometimes to the exclusion of affected communities, or that the naming and shaming tactic, long favored by many NGOs, has lost capacity to galvanize in an age when social media offers up a ready supply of atrocities. Even if these critiques have some weight, and I think they may, it's a distortion to lay much of the blame for the rise of populist authoritarianism at the feet of the human rights movement. It's not the tools of human rights that are giving rise to autocrats. It's the absence of economic opportunity for many. It's the paucity of imaginative political alternatives, and it's those strongmen's own ruthlessness in flouting democratic rules. But if rights and their legal underpinnings have gone underappreciated in recent years, the past 12 months have witnessed the beginning of their resurrection. Russia's illegal invasion of Ukraine and the mass atrocities which have followed have reminded us that human rights and international legal architecture, which gives them substance, still matter. The invasion and the ongoing defense of Ukraine underscore three fundamental truths. First, rights, justice, democracy. These are not empty rhetoric. They have concrete meaning and value, and yet it is often only when we are on the verge of losing them that we appreciate how important and, yes, precarious they are. Many of us in the United States could not have imagined that our own capital, the seat of legislative power in our government, could come under physical assault, or that an incumbent president would refuse to recognize the results of a free and fair election. Similarly, until last February, many too young to remember the Second World War may have understood the dictates of international law, the inviolability of borders, the right of people to choose their own rulers, the prohibitions against abusive conduct, even during armed conflict. Many may have understood these as uncontested platitudes, nice to say, but not worth much in the real world of hard power. The Russian invasion of Ukraine and its brutal targeting of civilians and their infrastructure have reminded us both that legal norms matter and that they may be lost. After February 24, the world has had to learn yet again that the protections of international human rights are neither inevitable nor irreversible. Russia is clearly showing us what a world without international law and rights would look like. Second lesson of Russia's aggressive war derives from the first. Human rights are proclaimed in print, or these days on a digital screen, but they are forged, defended, and expanded in struggle. There is no more vivid example than the millions of Ukrainians fighting for their freedom, their democracy, their very existence. And just as Ukrainians are mobilizing on the battlefield to preserve their country, they are also pushing for what President Zelensky has called a just peace, grounded not only in the return of Ukraine's occupied territory, but also in accountability for those most responsible for this illegal invasion. The world has learned that it was a mistake not to punish Putin for his prior acts of aggression in Crimea and eastern Ukraine, not to mention his troops' crimes in Georgia and Syria. A peace settlement without criminal charges against the most senior perpetrators of the current violence will not bring enduring peace. And so, even as the Ukrainian Prosecutor General and the International Criminal Court investigate war crimes, the United Nations General Assembly must create a new tribunal to try Russia's leadership singular crime of aggression. But if we really want to deter future dictators from launching aggressive war, it is not enough, though it is essential, to prosecute Russia's current rulers. We must also make clear that aggression, like atrocity crimes, will be punished whenever and wherever it occurs. And so the third truth of this war is that what is happening in Ukraine is of universal concern. It is, of course, Ukrainians who suffer most directly the heinous acts committed in Bucha and Mariupol and other countless towns that have been laid to waste. These are crimes against all humanity. In defending its own democracy, Ukraine is fighting to preserve an international order that we all depend upon. And in this case, Ukraine's cause really is the world. The global spotlight is rightfully aimed at Ukraine at present. We must not forget the other human rights crises that need and deserve international attention, from Myanmar to Ethiopia to Afghanistan to Palestine. And so while we must hold Putin and his henchmen to account, our task will not be complete until we bring the law to bear on other sites of serious crimes. The very notion of international justice demands that it be administered impartially and equally. Anything less is not worthy of the name. Thank you.
Thank you very much, Mr. GOLDSTON. And next we go to Kiev. Wayne Jordash is there advising Ukrainian government, and he's representing the organization Open Society Justice, Global Rights Compliance. And Wayne is a human rights lawyer with 20 years of experience. And when we talked yesterday, he said that initially, when the war started, he was not really for the tribunal, but he changed his opinion. So could you please explain? Wayne, the floor is yours.
Yeah, thank you very much. And thank you to the Estonian Institute of Human Rights and the Estonian Ministry of Foreign Affairs for this opportunity to address this panel. And of course, to appear alongside Andres, who I had the pleasure to meet in Kiev late last year. So yes, I have evolved, I think, over the last year. In March, when I was considering the possibility of a tribunal for the crime of aggression, of course, I recognized that there was an accountability gap. As we know, the ICC cannot prosecute Russia's aggression. We know that the Security Council will not refer the situation. And we know that national courts, including those in Ukraine, cannot prosecute or even investigate the leadership crime, certainly not against Putin or Lavrov, because of personal and functional immunities. These are, for national courts, a bar to these investigations and prosecutions. But we know that an international tribunal will be able to, in all likelihood, deal with these immunities. So, in the end, for an international tribunal, to put it simply, it may come down to a numbers game. If the majority in the General Assembly endorses a future tribunal, whether established by agreement between Ukraine and a number of states, or the EU or the Council of Europe, that ought to be sufficient to determine its international character and to be able to deny the personal and functional immunities. So why was I against the tribunal in the first place, and why have I come around to supporting such an institution? Those who say that a tribunal will be cheap and efficient and be able to easily establish responsibility, I think overstate the case. I think we should be aware of these claims. International lawyers and jurists often make these claims in relation to new proposed courts. Just for background, I've worked as a representative of two governments at the ICC and victims at the ICC, and as a defense lawyer at the Special Court for Sierra Leone, the Rwandan Tribunal, the Yugoslav Tribunal, and the ECCC at the Khmer Rouge Tribunal in Cambodia. So I understand how these international tribunals work. They're never cheap. They're never efficient. Linking high-ranking politicians or military individuals is never easy. Indeed, it's the biggest challenge in international criminal law. A tribunal to try the crime of aggression will be no exception. International and hybrid courts are plagued with bureaucracy, delay, and expense. The ICC has convicted 5 people in 20 years for international crimes, at an eye-watering cost of $1.5 billion. Even the International Criminal Tribunal for the former Yugoslavia, which has been by far and away the most successful of international courts, in 29 years has completed 111 trials and convicted 91 people. The cost of the ICTY and the ICTR was $1.2 billion and $1 billion respectively, at a cost of between 10 to 15 million per accused. So these are not cheap, these are not fast, and they are not in many ways efficient. The Special Court for Sierra Leone, which began its work in 2002, with a promise to do things more efficiently and effectively, promising to complete its 13 indictments in 3 years, in fact took 11 years to try 9 accused. Moreover, international courts have a habit of occupying a lot of space. They can suck the energy out of other important justice mechanisms. Has anyone heard of the Special Court? I beg your pardon. Has anyone heard of the Sierra Leonean Truth and Reconciliation Commission? Unlikely, despite the fact that the Sierra Leonean population needed to understand what precipitated the wave of brutality in Sierra Leone that took place between 1991 and 2001, despite the fact there was much to learn about why some people in Sierra Leone had turned on others with such ferocity. Despite that, very few people took notice of the Truth and Reconciliation Commission. In part, that was because the Special Court for Sierra Leone sucked the energy, sucked the attention out of local efforts. The budget for the Truth and Reconciliation Commission was $5 million. The budget for the Special Court for Sierra Leone to try the 9 people was $300 million. No national trials took place in Sierra Leone. The Special Court for Sierra Leone, with its narrow focus on criminal guilt and retribution, produced judgments which, in my view, are a shadow of the Truth and Reconciliation Commission judgment. So beware of those who say international tribunals are an answer to everything, and beware of those who do not understand the way in which international tribunals can diminish the support for other important endeavors. At the moment, Ukrainians' prosecution and investigations are already overwhelmed. They need a huge amount of support. My team of 25 Ukrainian and international lawyers are the main support for the prosecution. 25 people. We'll expand to 30. But you can imagine how, in effect, there's little we can do, and how much more support the prosecutor needs. These crimes are complex. The national justice system is not prepared for the magnitude of this task. And in reality, there's been already an underwhelming response by the international community to provide what is needed. Yes, it's unprecedented, but it is in no way impressive. The ICC is a troubled institution that is already starved of resources. It will probably never have more than 20 or so investigators in Ukraine. So the risk of present endeavors, the prosecutors in Ukraine's endeavors, the ICC's endeavors, is a real and present danger. Putting these logistical challenges aside, the Tribunal for the Crime of Aggression raises really serious questions of legitimacy and hypocrisy. The spectre and the shadow of Iraq really casts a shadow over any future tribunal for the crime of aggression. So why have I changed my mind? In the judgment of the International Military Tribunal at Nuremberg, following World War II, it was stated, quote, "War is essentially an evil thing. Its consequences are not confined to the belligerent states alone, but affect the whole world. To initiate a war of aggression, therefore, is not only an international crime, it is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole." Close quotes. Let's very quickly look at the whole. The Kremlin's inherently criminal mission to subjugate Ukraine is now clear from the patterns of crimes. I've seen this over the last year. It's not a plan just to occupy Ukraine. It's not a plan just to take territory. It's a plan to subjugate the Ukrainian population to Russian rule and to destroy Ukrainian identity. What does that mean in reality? It means that the objectives cannot be achieved without mass criminality, without massive commission of war crimes, without widespread and systematic crimes against humanity, and without, I suggest, in some places, genocide. Broadly, the plan contains 3 steps. First, to kill all the leaders, i.e. those who are vital for organizing civilian life. The definition of leaders is inherently elastic. The more Ukraine resists, the more that list expands to include all government, all politicians, all journalists and teachers and human rights activists and so on. It's the heart of the plan: decapitate the leaders. The second part of the plan is to capture, filtrate, identify, and re-educate any troublesome pro-Ukrainians and activists. Kill them if necessary. And the third part of the plan, the final objective, is to destroy Ukrainian identity through re-education, destruction of cultural objects, removal of the Ukrainian language, the attack on all Ukrainian signifiers. So the accumulated evil is shocking to the core. This was not an illegal evasion to save Russian speakers from genocide, or, as I've said, merely to occupy territory, or as in Iraq, some misguided mission to remove a dictator or spread democracy. It was a crime designed to open the door to a subjugation, dehumanization, brutalization of millions of innocent men, women, and children. It is an attack on the right to be free. It is an attack on the future. It is a monstrous example of a monstrous crime. Along with violations of international humanitarian law, it therefore must be prosecuted. The problems with the tribunal that I've identified will persist and must be confronted. They cannot be ignored. Any tribunal must work efficiently, effectively, and transparently. And we must be careful that it does not diminish the work of the Ukrainian Prosecutor General or the ICC. But if we do not investigate and prosecute those responsible for this crime, what does it say about our commitment to those innocents currently being enslaved in Ukrainian territory? What does it say about our commitment to the global world order? Thank you.
Thank you so much, Mr. Jordash from Kiev. And let's move on with our discussions. Myroslava, Ukrainian view on this, after this very pragmatic and realistic presentation from Kiev.
You know, now I'm thinking after such a comprehensive presentation from Wayne, what should I say? You know, it's always super challenging.
But you know that today we have discussed crimes, and there are many crimes which are committed by Russia in Ukraine. We have also seen the aftermath. We have seen the outcome on photos. So before I came onto the stage, I checked the figures. And about half an hour ago, it was 69,000 crimes committed. 69,000 crimes of war registered in Ukraine. So we have different cases. There are shootings, also killing, torture, sexual crimes, deportation. We have seen missile attacks which serve no military purpose. So the objective is to destroy the civil infrastructure. The aim is to cause destruction and just spread the horror. The aim is to leave people without water, without electricity. So the weather in Ukraine is more or less the same as it is in Tallinn today. And can this be called a genocide? I think there's millions of people who are sitting there in Ukraine without water, without electricity, without heat. They can definitely answer that question. Now, the basis of it is the crime of aggression. So, and you know that Ukrainian prosecutors and investigators are going to work 24 hours 7. And we have to say honestly that they are not able to fully investigate and prosecute all the crimes on the international level. So this is not only a question of resource or gathering evidence, but there are some legal challenges as well we face. For example, in order to study crimes against humanity, there is an immunity we have also discussed. So today in Ukraine, we are trying to assess all the possible methods in order to close the gaps. Most of the crimes, it could be said 90% of the crimes, will be then judged by the courts in Ukraine. But at the same time, we can say that we are working based on our national legislation. We can adjudicate or investigate people who have been wronged, and we can also investigate these powers who cause these wrongdoings. Because if we do have evidence, then we can move on to the court proceedings. Because when it comes to the victims and the relatives, then this court ruling is very important, because carrying out justice is the key for them. Now, the next level is our cooperation with other countries. This is something which I've seen that the research has started, or we're gathering evidence. Over 20 countries are helping us. We have different cooperation levels. So the closest cooperation right now, we have the joint investigation groups. The joint investigation team has Estonia, Latvia, Lithuania, Poland, Slovakia, Romania. And it includes Eurojust and the International Criminal Court. And this is the first time when we have participated in this joint investigation team. So where did this idea come from was we wanted to make sure we have an efficient, fast exchange of information, exchange of evidence, and the evidence which have been gathered in different countries will meet the legislative standards of that country, will be accepted by other courts. We are cooperating with other countries as well who are not part of this joint investigation team. The aim is not to carry out the same work twice, so want to make sure that this is all beneficial. The next level is the international level. So we are talking about the International Criminal Court, and we have very close cooperation with them. And we have the Rome Convention, so therefore we have started proceedings due to the situation in Ukraine. So this concerns crimes of war and genocide and crimes against humanity. In the Ukrainian society, we are looking forward to the results of these investigations because many countries are supporting these courts, and this is very important for us. We have certain shortcomings. So this is the crime of aggression. I'm not sure if you've seen the press conference this Wednesday, because our investigation team discussed the current situation, and they said that it said that when it comes to the plane Mi-17 being shot down, then as the Russian president is the only person to make the decisions regarding the use of such weapons in Ukraine, then the Russian president is the person who's responsible. And Ukrainian prosecutors said that we cannot continue the investigation. We have to stop the investigations because this person, Putin has immunity because he's the leader of a country, so therefore he has immunity from criminal prosecution, and we can see the same with the crime of aggression. So these three people, that means that they might go unpunished, but this impunity will cause the next wave of crimes. We talked about Crimea today. We talked about east of Ukraine, and all these things are interlinked. So Ukraine calls for the establishment of a special tribunal in order to break this chain of impunity, because I know that different countries have different attitudes. Some countries are supportive of this process, but we do continue step by step. So last week, the European Union confirmed their preparedness to support the work of our international center when it comes to the prosecution of crimes of aggression. It is very important for us to have your support, the support of all of you in all these directions. I would like to use this possibility and say that Estonian Prosecutor General is participating in this panel, and I would like to thank him personally and Estonian prosecutors who have been working with us from the beginning, and you are helping us in our investigations. This is very important because only with the joint efforts we can achieve justice for Ukraine and for the Ukrainians.
Thank you to Janika Merilo for excellent interpretation as well. But Prosecutor Parmas, what is Estonia doing in Ukraine? The work is done in the framework of the International Criminal Court, but Ukraine and Russia have not joined the statute. Well, Estonia is doing nothing in Ukraine. We act in Estonia. In Estonia, there is a large number of people who have fled the war in Ukraine here. Our neighboring country is Russia, so inevitably we immediately or in the future might be exposed to victims who are the victims of international crimes and possible perpetrators or people who aided and abetted the perpetrators. This is where Estonian law enforcement comes in, and also other countries' law enforcement institutions in the joint investigation team. And we probably all will have enough work to do for generations. After the Second World War, the prosecution of the Nazi crimes show that the most recent cases were still in court last year. So the International Criminal Court has started collecting evidence, and it's quite a contradictory organization, like Mr. Jordash said, because a number of countries have not joined it, and the US, Ukraine, and Russia are not members. What is the competence of this court to deal with Ukrainian related issues? Yes, Ukraine is not a member state of the International Criminal Court, but in the statutes of the International Criminal Court, it is foreseen that a country that is not a member state can submit a declaration and recognize the court's competence to investigate the crimes committed on the territory of this state. And Ukraine has submitted 2 declarations of this kind, as far as I know, in 2014 and 2015, regarding the crimes committed in the framework of Maidan, and also the crimes committed during the actual start of the war in Donbass. So due to this, the International Criminal Court has the competence, also regarding Russians who have committed the crimes, despite the fact that Russia is not a member state of the court and has not recognized the competence of the ICC. It's an entirely different matter how to get a hold of these people who have or might have committed the crimes. And this takes effort from the international community. It presumes that similar cases will not take place in the future, as have taken place repeatedly so far, that people who are fugitive based on the European arrest warrant, another member state is required to extradite this person to the requesting member state, but does not, like Austria. In a well-known case a couple of years ago, who did not extradite to Lithuania a former KGB officer who personally had blood on his hands in the 1991 events of Lithuania. So the basis of prosecution is international cooperation. Yes, it is inevitable in the kind of situations we are facing. You were in The Hague, in the courtroom, where there were attempts made to prosecute Russia in some way in March last year, and the Russian representative did not appear. Can you describe the situation? You were on site as an eyewitness.
Sorry. Так, дійсно, ви знаєте, це був дуже такий... I will speak in English, it would be easier. Then, you know, it was a very interesting and very delicate moment, you know, because, of course, on Ukrainian side, we didn't have a lot of expectations, you know, that Russia will come and say something, but at least you always want to listen something. What is behind the scene? And when we heard the court decision, this decision that Russia need to stop and take out the forces from Ukraine, also both Russia and Russian allied, and somehow deep in my heart, you know, I really hoped that something will come to light in Russia and they will use this as an opportunity to comply with international law, and that they will withdraw their forces, their fighters, but it never happened, you know. So, and it was such a moment, you know, when you understand that this line was somehow crossed, the line when the international law was fully perpetrated.
Läheme oma aruteluga nüüd edasi või tagasi New Yorki. Mr. Goldstone, what should happen at the United Nations that this special tribunal would be created? We know that the Security Council probably will not act, but how binding the GA decisions on this would be, and would there be enough countries supporting that decisions? How you see that from New York?
Thank you, and thanks for this rich discussion. Let me just step back a second to answer that. I think we've seen a number of states come forward in recent weeks. We've seen the International Center established in The Hague. We've seen various proposals. I think of great interest was the comments of the German Foreign Minister Baerbock a couple of weeks ago, where she articulated a two-path forward. One, the establishment of a hybrid tribunal, and secondly, and parallel, an effort to amend the Rome Statute to correct what is now a deep gap. That is that persons who are citizens of non-member states cannot be prosecuted by the court for the crime of aggression, even though they may be for the core crimes of war crimes, crimes against humanity, and genocide. So she proposed both of those paths going forward, and I think that's what has to happen. But I would urge that there are a couple of tweaks to that proposal. When talking about a hybrid tribunal rooted in the Ukrainian system with international elements, I think there's value to that. Ukraine is the victim state, and we should do everything we can to ensure that its system and its people are involved in the effort to address these crimes. But at the same time, we know that there are issues with Ukrainian domestic law, including in its own definition of aggression. So I think there is precedent for a hybrid tribunal that has its own statute that includes both international crimes and national crimes. And I think one must ensure that the Rome Statute crime of aggression be incorporated in the statute of a hybrid court, to ensure that the leadership element of that crime, that is the leadership, those who have the power to and the authority to move troops, to order an invasion, those are the targets of an investigation of aggression. That will require Ukraine, I imagine, to amend its law, if not its constitution. But again, I think it's fair to ask of our friends in Ukraine in order to enable this to happen. A second challenge will be immunities. The German proposal suggested that with a hybrid tribunal, the trio, the leadership of the Russian Federation that enjoys personal immunity under international law would not be subject to prosecution. I think that is unacceptable. I think the crime of aggression and any mechanism to address aggression has to address the senior leadership. And in order for that to happen, it has to be a sufficiently international tribunal to be saying that it is acting not on behalf of a national system, but rather of the entire international community. And for that to happen, one needs ultimately the General Assembly to act. And it must do so in as overwhelming a way as possible. But in order to get General Assembly backing, for the reasons that we heard Wayne articulate, there's a deep amount of skepticism in certain parts of the world about, even though what is happening in Ukraine is horrific, why were not other acts of aggression addressed in the past? And so I think in order to do that, in order to get the backing politically of those states that are skeptical, it is essential to commit in a serious way to the second path that the German foreign minister articulated of amending the Rome Statute. And that's going to be quite a political lift to have happen. But I think ultimately a hybrid tribunal rooted in the Ukrainian system, but with components with both international and Ukrainian law that has the backing of the United Nations General Assembly is really the ideal solution for this. It will not be politically easy to get this to happen, but I don't think we have an alternative than to try.
Thank you very much. Let's go back to Kiev. Mr. Jordash, your positive scenario for the future on this issue. What would be the most positive way? We heard lots of skepticism, but if things would go in the right direction, what this direction should be?
Well, I see things quite globally in the sense that I would like to see the tribunal, whichever format emerges, obviously, as James was saying, endorsed by the General Assembly, by as many states as possible. But I would also like to see greater support given to the ICC to deal with genocide, crimes against humanity, and war crimes. I'd like to see greater resources being given to the Ukrainian prosecutors. And so far, I think it's fair to say that the resources that are being given by the international community to the Ukrainian prosecutors are underwhelming and certainly not up to the enormity of the task. The number of crimes being committed in Ukraine is enormous, and the challenges ahead in terms of the generational work that Andres talked about really is demanding, and we really need to do more. And I would also say we need to do more in terms of using universal jurisdiction principles. Many countries, I think up to 20 countries, have opened up investigations into the core international crimes. And I'd like to see this followed through. And what I mean by that is if we look at the way in which states generally investigate and prosecute according to universal jurisdiction principles, it's entirely underwhelming. A handful of investigations here, a handful of prosecutions there. Germany has been, without a doubt, the world leader in terms of investigating, for example, Syrian crimes. We need to see such action. I would like to see in the next 5 years a web of accountability emerge for Russian crimes across the whole region globally, so that we have not just a tribunal to prosecute the crime of aggression, not just the ICC, but individual investigations and prosecutions occurring across Europe and across globally. That anything less than that is going to be an underwhelming response to the enormity of the crimes that are being committed in Ukraine at this moment, and which undoubtedly will continue as Russia continues to occupy Ukrainian territory.
Thank you very much. Miroslava, me kuuleme pidevalt võrdlusi Nürnbergi tribunaliga. Let me ask in English, it will be better understood. We hear constantly the comparisons with Nuremberg Tribunal. The Nuremberg Tribunal was established after the war was over, but the war is going on now, and we are discussing what's going to happen. So what's your positive scenario? Well, the most positive way? I mean, first, the war has to end.
Well, once again, I would reiterate these principles that I said, about this justice delayed, justice denied. Why? Because it's very important to deliver justice when you can. Because I remember when we had the first trials, maybe in half a year, and people were like, okay, but how are you doing this? Maybe you should wait. Maybe you should show the whole line of command, and etc., etc. And I would say that the perfect scenario for us is to prosecute when and with resources we have, So if we have the chance to prosecute in national jurisdiction, Ukrainian national jurisdiction, we will do this. For example, if you have the direct perpetrator, or etc. And we are also working with our partners from countries of G8 and other countries of universal jurisdiction. Because as Wayne mentioned, Syria, for example, they have, with regard to Syria, Germany has this very good example of investigation without access to the territory, So this is another field where we can work together. And of course, we really looking for this international criminal justice input, so both from ICC, because ICC has a mandate. The situation in Ukraine is not new to the ICC because they were conducting their preliminary examinations since 2014, and they have their jurisdiction over all the territory of Ukraine, so starting from November 2013. And so this is something that we are really looking for, and with regard also the tribunal, because as it was said also by James, for us it's really unacceptable, the idea that these three guys who are obviously, okay, I will be very legally correct, allegedly but obviously involved and gave some direct orders, would go unpunished,
Mr. Parmas, your positive scenario, before I give the floor to questions. I'd like to come back to the Nuremberg example. It's not right to overexploit this example. The Nuremberg court was established after World War II, but it was decided during the war to establish the court in a similar situation to today's. We will win at one point, and then the criminals must be prosecuted for the crimes. And this is the attitude we need to cultivate. The positive scenario is that at one point we need to get ourselves together and say that we're not going to take a step back anymore. There is a red line, not a rubber band that can be flexed a little further. When we did nothing after Georgia, when we did nothing after the war started in Ukraine in 2014, if we do nothing now, then what are we waiting for? What kind of a cataclysm should take place for us to realize that something must be done? I believe that we're not there yet. Everything that is discussed, that this principle shift in thinking, and that now the world is different, the shift in paradigm, we speak about it, but it has not taken place. Nothing has taken place yet. What should take place for it to happen? That I believe that something has taken place when the International Tribunal has been established, one with considerable support from different countries. The most realistic place to seek it is the UN General Assembly. And there is the backing of the majority of countries, not that most of them are looking away or are just sort of vague, that, Ukraine could do it as a hybrid court, and they just try to divert attention away from the leadership of the country being accountable. And I'd like to speak about something else. Where does it come from that the head of the country in office or Minister of Foreign Affairs cannot be prosecuted, is not accountable? There's international law of diplomacy and a principle that the high representatives of a state have immunity, and the idea is that countries can communicate with each other. And on the other hand, there's a central principle of international law that international crimes are prosecuted, and no position releases you from accountability. So my question is, it's not difficult to see that these principles are of equal weight, that these principles are in contradiction. What is left of this weak international law if we stand by the 2002 Hague International Court verdict, where it states that the Minister of Foreign Affairs in office can only be prosecuted separately. It was a wrong decision. It did not weigh what is more important. And looking at the events that followed, especially the war at hand, which is the greatest cataclysm witnessed in our generation, it should be crystal clear which should be weightier. We also have Lauri Mälksoo, an expert of international law in the audience, whom we asked to listen to this discussion. So what is left of international law? What is your understanding of this? On the territory of international law, speaking about the importance of the tribunal. I will speak in English.
Perfect.
I liked how Wayne Jordash concluded his thoughts, and that was with a rhetorical question: what remains of international law? What does it say about international law if these things remain unpunished? And I think this is where we have to pick up, and we can jump back to Nuremberg, because Nuremberg is actually a great example how there are revolutionary moments in the development of international criminal law, because there were many let's say, concerns about legality, nullum crimen sine lege. Can we do that? Can we do this? But in revolutionary moments, law will be advanced with a kind of leap. They decided in the London Statute for Nuremberg trial, yes, we can do that. And then they did it, although there were certain concerns on legality in terms of criminal responsibility for those acts. So if it could be done then, a leap can also be done now. For example, think about this head of state immunity. First of all, a lot of these things about head of state immunity are debated. There are different views. Some are more conservative, some are more progressive, so to speak. I think one view is also that, okay, head of state immunity applies to people who are in office, but we can also wait until they are no longer in office. So obviously, when we can get them, they will be no longer in office by definition. And anyway, as Andres Parmas pointed out, there is this difficulty. How do you explain so strong head of state immunity with the rest of international law, so to speak? But the problem is, and I wanted to also bring this example answering NEEME's question, so how does it look like in New York? I want to give you one fact. There have been 3 votes in the General Assembly on Ukraine. In the first one, it was to call it aggression. 141 states in favor. The second one was in October, to call the annexation of 4 territories illegal, to call that illegal annexation. That was already 143. Now, in November, there was a third General Assembly resolution that concerned the call that Russia will be responsible as a state for that. State responsibility would be applied. And the number of supports dropped. It was suddenly 95 plus, I think. And that gives a certain indication. And the bigger problem is that, and I think we talk too rarely about that basically a lot of the world thinks that historically they got, pardon my French, they got damaged by the Western world. Their grievances are to the Western world because of colonialism, and then they ask, so basically after a few drinks they would say that you worry so much about Ukraine because these are also white people like you, or in the global north, so to speak. I think this argument is said. And that, there hasn't been a similar movement to establish criminal responsibility, for example, certain cases when the US intervention was considered illegal and something. So now when we want, and we are not talking about the simple majority of General Assembly, we are talking about the 2/3 majority based on a sort of constitutional law of the UN, a resolution from 1950 called Uniting for Peace, a resolution that requires 2/3 majority. And then in a way, we now have all that burden of history. I think many of those states can be convinced. But I think it's also an opportunity for Western countries to look in the mirror and to ask themselves, what do they have to do differently in the future as well? Because many countries won't believe Western governments for their beautiful words. Thank you.
Thank you. There are so many ideas to discuss and think, but our time is running out, so we decided that the conference ends at 5:30 as we promised. So for final words, I would ask some thoughts from you, Miroslava. You are in The Hague and you see this hesitancy from the state, and you are from the state where those crimes are taking place. So on the human level.
Indeed, when we follow all the different discussions, you really try to put yourself in the shoes of that country that you are speaking to. I remember when we were facing on the 20th, almost a year ago, and I was facing a colleague from very good country, very good colleague. We had a very good personal relationships, and I was like, you see, what shall we do? Let's support, let's do this, weep on, different approach. And he was like, yes, it's all our sympathy to you, but this is a global matter. It's Taiwan, this is something. And that's why, maybe from my personal perspective, it's also, as you said, it's also very important to understand the other party, but also it's important to make all these efforts for other parties to understand us, that we are also fighting this imperialism, we're also fighting this colonial politic, We don't want to be the part of something. We want to be independent, and we want to restore our country, and we want justice for our country.
Thank you. And these are the final thoughts for this panel. So thank you for everybody for participating.